Good morning. Today I am going to discuss with you about a Mohammedan law, how property divorce with this case law, so that you can very well understand the concept of shares as directed by Quran and what happens if deceased have no issues, so many things are there. So first I will say that AR 2025 Supreme Court 5083. AR 2025 Supreme Court 5083. Johra B and another versus Imam Khan and Elas and others. Actually what happened? The word matruka property has been discussed here. See, plaintiff is a brother of the deceased, claimed that all the property left behind the deceased was matruka property and he would be entitled to 3/4 of the total property since deceased was issueless. Widow of deceased pleaded that since one plot of land stood transferred during the lifetime of deceased under an agreement to sale and other property was also sold, nothing remained to be partitioned as matruka property. So the Supreme Court has concurrent with High Court and Appellate Court judgment stating that agreement to sell is not sale deed. No value in the IRS law as per section 54 of the Transfer of Property Act. And the sale deed which the wife claiming to have executed is also not valid because she is having only 1/4 share. Therefore, the plaintiff claimed that she is entitled for 3/4 share has been accepted. Then now they at paragraph 7 they have discussed about section 54 as to how agreement of sale is not sale. Okay, then question arises at paragraph 33, the court, the transfer defined with reference to the word convey. The word conveys in section 5 of Transfer of Property Act is used in the wider sense of conveying ownership. So that was discussed. Then what is matruka? That is discussed at paragraph 8. In AR 2001 SC 3067, Jamil Ahmed versus 5th ADJ Moradabad, property both movable as well as immovable left by deceased Muslim is called matruka. The scheme of distribution of matruka among the heirs of deceased Muslim is first that part of the matruka which is covered by a will of the deceased. If there is a valid will, subject to maximum of 1/3, then will be separated and given to the legatee. Balance of matruka alone is distributed among the heirs in the proportionate ordained under the Mohammedan law. However, then they have discussed about further that matruka, the property both movable as well as immovable left by deceased Muslim is called matruka property. The Dictionary of Urdu, Classical Hindu and English, written by John T. Potts, matruka is the estate of deceased person. So that was also different. Then at paragraph 11, the Mohammedan law, how the property is divided, has been discussed. Then they have also said there are 3 classes of legal heirs. Number 1, sharers. Those who are entitled to a prescribed share of inheritance. Then residuaries, left out property. That will be go to the sharers satisfied. After giving claim of the sharers, whatever left out, he will get. Distant kinder, when there is no residuaries, then distant kinders will be entitled as per the share. The problem is, you see one thing, under Hindu law, the shares will be first class legaler, second class legaler, then agnates and cognates. That agnates and cognates are here, they are called distant kinders. So this is what a Muslim law, you can go through this deeply very short judgment, however very precise and effective judgment. I hope you understand my endeavor to bring this case. This is AR 2025 Supreme Court 5083 Johar B and another versus Imam Khan and others. Best wishes.